Hi, my name is Attorney Tim Sechler from the Sechler Law Firm in Mars, Pennsylvania. We help folks with estate planning and elder law needs kind of across Western Pennsylvania. I am doing this presentation today to give you sort of my take on estate planning and asset protection. It is a variation of a workshop we frequently do in our office. When folks call our office asking us for help, do I need a will, do I need a trust, do I need a power of attorney, any estate planning concerns. We typically ask folks to come to a workshop first, but we understand not everybody can come to the in-person workshop. So we're doing this video to present that information. This is the stuff I think people need to know before making a decision on an estate plan. I don't think you can sit down with a lawyer and have it figured out in a meeting whether you should use a will, whether you should use a trust, what do those documents need to say. This process and this area of the law is just way too complicated for that. And so we're going to do this talk today to give you my take on what I think you need to know. I'm going to bring up some slides to do this. And here we go. So a little bit about my law firm. My main office is in Mars, Pennsylvania. We also have offices in Newcastle and in Butler and in the South Hills. I am a veteran. I served in Afghanistan back in 2005 and 6. And I am what's called a certified elder law attorney. So in the practice of law, you get all these letters after your name over time. A certified elder law attorney is one that I take some pride in. There aren't a ton of us around, and if you're dealing with somebody, look, by the end of this talk, you might think I'm a jerk and you don't want to work with me at all. Fine. But if you are concerned about estate planning work and elder law work in general, you can work with somebody with this certification. This is somebody who's done this practice area for at least 5 years to be able to get enough cases to sit for a really tricky test. And so if you're dealing with somebody that's certified in the elder law world, you've got somebody with some real experience. Okay, and just a little disclaimer before I get into the information. I'm presenting this information for education purposes. It is true the day I'm presenting this in Pennsylvania. Laws change, laws differ across state lines. You shouldn't really do estate planning at all without the assistance of an attorney. There's too many nuances. There's too many areas to screw it up. I know there's all these online things where you get documents, but those documents typically don't stack up. And so there's a real difference between having a document and having a good estate plan in place. And I'm gonna share some of that information with you here today. So here's our agenda. I'm going to chat with you about control and access. This is really the name of the game. If we're doing an estate plan, I don't care if we're talking about a will, a trust, a power of attorney. All we're really ever answering is the question: who's in control of me and my things? Who's got access to me and my things, and when? We're going to talk about those documents I've been mentioning, and also some of the reasons we use them: taxes and asset protection as it relates to this sort of crazy nursing home Medicaid system that we have. So control and access is the name of the game. There's 3 time periods that are really relevant: when I'm alive and well, if I get sick and I'm incapacitated, and then when I pass away. So as I'm sitting here today, I'm alive and well, I'm in control of my stuff, I have access to my stuff, I can make decisions with regard to my stuff. But what happens if I'm incapacitated? I'm at the office, if I'm on my way home this afternoon and I get into a car accident and I bounce my head off of the dashboard. Now, who's making the decisions tomorrow? Who's in control of me? Who's in control of my stuff? And who's got access to that stuff? And then the next time period, and we're going to go through these sort of sequentially, is who's in control if I pass away. So if I am in an accident that results in my death, now who's in control? Who's got access to my stuff, to my money? Who's in control of those dollars for the benefit of my kids until what birthday? And so there are, you're going to get sort of my take on that. So in the event I would become incapacitated, we really need to break this down into two sort of thought processes. First, who's making my legal and my financial decisions? And then second, who is sort of in control of my healthcare decision-making? Now, the way that we answer the financial and legal decision-making is with a document typically called a power of attorney. If you don't do a power of attorney, you're stuck in this process called guardianship, where a judge is going to appoint someone to make legal and financial decisions on your behalf, and then they have to report back to the judge with what they're doing with your stuff from time to time. And it's sort of this invasive, expensive process, and most families don't want to go through this headache. So they answer the question about incapacity during decision-making during incapacity with a document called a durable power of attorney. Now, here's the thing about them. I personally believe this is often the most important estate planning document, especially when we get into the elder law world. So like we really see a couple of different types of cases. I do wills and trusts for people. We do post-death administration work. And then we also do what we call nursing home crisis cases. And that is when someone is in the nursing home and they're going through maybe $10,000 a month paying that nursing home. Is there anything we can do to help them protect assets, protect the house, protect some things for mom if dad's in the nursing home, that case. Now, if I'm doing that type of case, it really depends on, what I'm allowed to do to help a family really depends on what the power of attorney says. And here's the thing. If you don't have a power of attorney, you probably need a power of attorney. This document is crucial. It names who can make your decisions in the event you can't anymore. But they're not all drafted the same. And one of the key things that differs amongst the documents is the gifting provision. So like if we have that case where someone's in the nursing home, we're trying to protect assets, often we want to be able to shift assets between spouses or maybe do some gifting. Sometimes we'll gift the house to the kids or to a trust for the benefit of the kids to try to protect assets. To be able to do transfers like that, gifting of assets needs to be authorized expressly in the power of attorney document. So don't assume that just because you have a power of attorney that you have a good power of attorney. The document needs to authorize. In my opinion, again, you need to get your own and make your own decisions and work with an attorney. But if you are concerned about the elder law issues, if you are concerned about asset protection, you should have a power of attorney that authorizes unlimited amounts of gifting to a specified class of people, typically the people who would otherwise inherit from you. But now if you're a family member, if your kid or whomever is serving as your power of attorney, your agent under the power of attorney, comes to us and says, we want to try to protect dad's house, now we've got the ability to move the money. We've got the ability to move unlimited sums of money to protect it. Most power of attorney documents don't have the unlimited gifting language. They have what's called limited gifting, which means about $15,000 to your close family members. But look, if we're trying to protect your house and I need to change ownership of the house to protect it, and the power of attorney document is limited to limited gifting, $15,000, well, I can't very well move the house. It's worth more than $15,000. And so that's one of the biggest problems I see is that people have not enough legal authority, not enough muscle, so to speak, in the power of attorney. Now, there's also the healthcare decision-making document in Pennsylvania, where we commonly do this with a document called an advance directive, which is a two-part document. The first is it names your healthcare agent, the person who's supposed to make healthcare decisions for you. And then the second part is we give them some instructions, typically around end of life. In my documents, we also give some instruction in the event in the event of dementia. How would you want to be treated? So two-part document. We name the person who's supposed to make the healthcare decisions, and then we tell them what to do. The next time period that matters is control and access of your stuff after you've passed away. And the most common question we get in our office is, do we need a will or do you need a trust? Here's what I think you need to know first. How do you own your stuff? There's different ways that we own our assets. We can own them jointly, we can own them individually, we can own them with beneficiary designations, and that all impacts how the estate planning works. What is a will? What is probate? What is a trust? And so these are the different types of legal ownership. We can own things jointly. My wife and I, both of our names are on the primary checking account. If I pass away, that account is now hers. It does not matter what my will says. That's going to go straight to her. There's also assets that are beneficiary designated. So think life insurance or your retirement accounts. Those assets, you've told your financial institution, whoever that is, your bank, your financial advisor, you've put beneficiary designations on those accounts. So the asset is yours during your life, but when you pass away, you've told them where to send the money. They don't care what your will says. They're going to send it wherever the contract says they're supposed to. So the only asset then that goes through a will are assets that you own in your own name, individually owned assets. This is why, if you think about a married case, typically when the first spouse passes away, there is no estate to pass away because husband and wife tend to own everything joint or beneficiary designated to each other. And so when the first spouse passes away, if the husband passes away first, now mom just owns the assets. But then when she passes away, now she has the house in her own name. She has the bank in her own name. And when she passes, those assets are going to go through her will. Right now, so let's talk about a will. A will is a document that names who gets your stuff. It only governs those assets in your own name. It names an executor. That's the person who's in control. Remember, control, access. So the person in control is the executor. And the reason my slide says kind of is because ultimately the judge is in control. This when you pass away and stuff goes through your will, the assets go through this process called probate. And probate, by definition, is the administration of an estate through the courthouse. Now, there's an interesting thing. I'm going to go back a slide. See, a lot of financial advisors and a lot of folks, and even some attorneys will tell you, you should just do beneficiary designations on your accounts. Now, beneficiary designations are attractive. They're enticing because it's easy, right? I can just tell the bank or the financial institution where to send the money, and then I don't need a will, and that's all great. But here, the problem with beneficiary designations and relying on them solely in an estate plan is that a beneficiary designation only answers one question. And that question is, who gets it? When I pass away, who gets it? But, that's not the toughest question. We hardly ever get that one wrong. Equal shares to the kids, more to this kid, more to my nephew, whatever. But the challenge with this is that a good estate plan plans for contingencies. And what I mean by that is if you name beneficiary designations on all your accounts, that doesn't answer what happens if my kid dies before me. It might. What happens if the money is going to now my son's kid, my grandkid? What happens if my grandchild is underage? What if they're disabled? What happens if I give my assets to my kid and my kid goes through a divorce right away? What happens if I give my money to my spouse is in the nursing home? What happens if my kid is got a gambling problem or a drinking problem? See, those questions are the issues that really blow up a family. Those questions are the ones that will take away your life savings. It's not the who gets it, right? So beneficiary designations are attractive because they're easy and we just get to say who gets it, but they don't allow you to do any of that contingency planning. Now, a will allows you to answer those other important questions, the what ifs, the what if my kid passes away first. But wills must go through this process called probate. So probate, by definition, is the administration of an estate through the courthouse. So when you pass away, the executor of your will has to get sworn into the courthouse. We have to put certain things in the newspaper. Controls ultimately with the judge. It's expensive. It's not uncommon in Pennsylvania for lawyers to charge your executor on a percentage basis of the assets. So somewhere, say, like between 3-5% of your net worth just to get the stuff to the kids. So it's expensive. And it typically takes about a year before we're making distributions to the kids. And then there's this issue about whether your kids are going to fight, because if your kids are going to fight, this is where it happens. All the chips are sort of out on the table. We're in the courthouse anyway. We may as well are, this is, and not all will challenges are bad. Sometimes it may be that, what, brother, I know dad's will says 50-50, but you've been living in Las Vegas for the last 5 years. I've been sleeping on dad's couch. I've changed his diapers in the middle of the night. I've been his primary caregiver. I've had to take reduced hours of work. My marriage is on the rocks and I need compensated. And so like these conversations are taking place out there. Now, one of the things is, do we want them to be in the courthouse? Do we want it in the courthouse with the court reporter and the newspaper reporter, or should we keep this as more of a private matter? And so for all of these reasons, advisors, financial advisors, lawyers will talk to you about avoiding probate. Now, one way that we avoid probate is with a document called a revocable living trust. Now, with a revocable living trust, the idea is simple. Now, I've got a slide of a little red wagon. I'm gonna close the slides and do this sort of in person. But the idea here is I love using the analysis of the little red wagon to explain trust. And so the idea is the only place a trust exists physically is paperwork, right? I, as a lawyer, draw up your documents, you sign your documents, and when you do, you just gave birth to this new legal entity called a trust. Now, the terms of that trust document govern what happens next, right? What happens, and so there's 3 people involved. If this is my trust, I'm creating my trust, I sign the document, and then I give ownership of some of my stuff to that trust. Now, I don't technically own the dollar anymore. Now the trust owns the dollar. But see, ownership isn't as important. What's really important is control and access. So the person in control of the little red wagon, the person in control of the trust is called the trustee. So the person who created it is called the grantor. I create the trust, I grant ownership of my stuff to the trust. The trustee is the person who makes the decisions. The people who can access the dollar and use it, now those people are called beneficiaries. So the three people. I, as the grantor, create my trust. I'm in control of my trust, and I may or may not be the beneficiary of the trust, depending on the type of trust. Now, back to the slides. In a revocable living trust, I'm going to be all three people. So I'm going to create my trust. I'm going to put my dollar into the trust, and I'm going to be my own trustee. So I'm making all of the decisions relevant to the stuff that's in the trust. And in a revocable living trust, I'm also the beneficiary. Now, this could be joint if it's me and my wife creating the trust. So we could be the joint trustees. We can be the joint beneficiaries. So I can use this, the assets that are in the trust however I want. I can buy a house. I can buy a car. I can buy groceries. I can go on vacation. There's no restrictions on my ability to access the dollars in the trust. So why do people use these things? Well, understand that the revocable living trust is an alternative to a will-based plan. So a will-based plan is a will with a financial power of attorney and a healthcare directive. And the revocable living trust is typically used in place of the will. And so then the idea is if I put my stuff in the trust, I can use the dollars however I want. But when I pass away, I didn't technically own the dollar anymore. The trust owns the dollar, right? And when I died, the trust doesn't. It's just a new period of time in the trust life. And so the trust document says, upon Tim's death, distribute the stuff to his kids in equal shares, the same instructions that would have been in the will. But the difference is we don't need to go through the courthouse. We don't need to go through the probate process to make it happen. And so tends to save the family some time, tends to save the family some expense and just some general headache. And so revocable living trusts are used by families who want to maintain control of their assets, but avoid probate. And I just want to make a real quick point, okay? So we've already talked about three different ways we can leave assets to people: joint beneficiary designated, wills, and now a revocable living trust. Beneficiary designations are great because you can avoid probate, and it's real easy, and it just gets to the family lickety-split. But you don't get to answer those other important what-if contingency questions. Wills are great because you get to answer those other important questions, but when you pass away, we have to go through the probate court. So revocable living trusts fit a nice spot where families want to both avoid probate, get the stuff to the family quickly, but also answer those other important contingency questions. What happens if my kid inherits the money and then goes through the divorce? Okay, so revocable living trust is typically used in the same kind of fashion as a will would be used. We put your stuff into the trust. The trust may end up owning your house and some money, but when you pass away, it's the trust that gets the stuff to the kids. And trusts are administered around a lawyer's conference table rather than through the courthouse. Now, I want to talk to you about one additional type of trust today, and that is what we call an asset protection trust. So this trust is a trust that is irrevocable. So then the idea is I've got my little red wagon. I'm going to put my stuff in the little red wagon, and then we put a lid on it. I cannot get that dollar anymore. I've given up access. Now, I may maintain some controls. I could be my own trustee. I could name who the trustee is. I might be able to change beneficiaries over time. So given whatever your decisions are, again, you need to work with your attorney to figure out what works in your jurisdiction. But an asset protection trust is typically a trust that is used to maintain certain controls over the dollars, but you give up access to those dollars. And the reason you end up giving up access to the dollars is because if I can't get to the dollar, my creditors and predators can't get to the dollar either. So if I ever end up sick, if I need long-term care and I'm trying to become eligible for Medicaid to pay for like a nursing home, if I cannot get to the dollar that's in the trust, then how could Medicaid force me to get to the dollar to pay the nursing home? I'm not allowed. It would be an illegal distribution. And so you can create an irrevocable trust, an asset protection trust that allows you to protect assets, but also maintain some control over it. Now, a bit about this. The word irrevocable tends to scare people. It sounds like it's this permanent thing that's inflexible and all the rest. But it's possible to draft irrevocable trusts and work within a family to make this pretty flexible. So, for example, you could do an irrevocable trust that has what's called some type of a power of appointment in it. And a power of appointment is generally the idea that I can change the beneficiaries of the trust. So if I can change the beneficiaries now, and I also could be given like the authority to manage investment decisions, or I could have the ability to be the trustee or fire the trustee who's on the trustee. So if I'm sort of in control of who's in control, and if I'm in control of who can have access, then I'm really like, you know, you can almost think about this like I'm the coach of the football team, right? So you got the quarterback as the trustee, and you've got the beneficiaries who are the other players. But look, if they don't do what I say, I have the ability as the coach to sort of move them around or take them out or do whatever the case is. And so you can use an irrevocable trust and maintain some control and some flexibility. And what's nice about that is, so the idea is we don't put all your stuff into an irrevocable trust. You put in some of the stuff. We commonly would put in a house and some money, then you leave other dollars outside of the trust. So then the thought process would be we're living on the assets that are not in the trust in order to protect the assets that are in the trust. But what happens if like the money I left out gets too small and now I want access to the stuff that's in the trust? I can't have it, right? I've given up access. I'm not a beneficiary of the trust, but the trust does have beneficiaries. And that would typically be your kids, right? So if the assets are in the trust and I need to get to them, I can't. If I could get to them, the nursing home can get to them. But I could make a distribution to my kids, and then my kids own the money. Once the kids own the money, they can do whatever they want with it. They can go to vacation, they could buy their own car, or if my kids still love me, they might give the money back to me. So I could make a distribution from the trust, goes to the kids. Kids still love their dad. They give me the money that I need to get through. Now, this does result in kind of a complicated, there's typically a couple of questions here. One is, what are the tax ramifications of this? And then second, one of the questions is, well, what happens if I make a distribution from my trust and then it goes to the kid and the kid doesn't give me my money back? Well, the kid gets to keep the money, right? You have very little recourse, except remember, you could have maintained the ability to change beneficiaries. So if the kid ran off with the dollars and didn't give them back to you, you really don't have any recourse as to those dollars. But you could fire him. You could exercise your power of appointment to fire that child as a beneficiary, and then they're essentially disinherited. And it's been my experience that when you threaten to disinherit a child, they're probably going to give you your money back. But look, they don't have to. And that's what's key, because Medicaid law, when Medicaid looks at an irrevocable trust, it's a question of access. Can the person who's applying for Medicaid have access to the assets in the trust? And if the answer to that is no, then they're not an available resource for the nursing home. Now, from a tax standpoint, the IRS is all about control. So the IRS takes a look at these trusts and they say, well, look, if you create this trust and you maintain all kind of control over the money in the trust, then we're going to continue to tax you on the money because you haven't given up enough control, right? So, and this makes sense. Like if you think about somebody that has a whole lot of money, like really, really wealthy people, they know that they're going to get taxed through the roof because they're in high tax brackets, or because when they pass away, they're going to have a federal estate tax. And so they want to distance themselves from the money so that they can't be taxed on it. And this is an overgeneralization, but the idea is I want to get away from my money. The IRS can't tax me on it, but I don't want to give up control. So you know what? I'm going to put my money into a trust, getting it away from me, but I'm going to be the trustee on the trust, or I'm going to do some other thing that allows me to maintain control. And the IRS saw through that. So a long time ago, they created these things called the grantor trust rules. It says if you create this trust and you put stuff in it, but you maintain control, as far as the IRS is concerned, it's still you. You have not given up access to the money. You've not distanced yourself from the money enough. And so when you put assets into the trust, even though it's an irrevocable trust, it could be drafted such that if this is my trust and I put in my stuff, the trust still has my social security number, which means those dollars, if they earn anything, are going to be available for me. They're going to, or not available for me, but they're going to be on my tax return every year on my personal 1040. And so not much changes from a tax standpoint for me when I fund the trust as far as income taxes are concerned or estate inclusion. When I pass away, then let's get back to the slides here a bit, because there are some slides coming up on the taxes. So just quick review. We're using wills, revocable living trust, or asset protection trust are kind of like the three main estate plans that we've been talking about. Any of those three, you would need a power of attorney and a healthcare directive as well. I want to chat with you about taxes a little bit, because when transferring assets to the trust, I told you there's no real tax ramifications, because from an income tax standpoint, the trust is still me. Now, if I make a distribution from the trust to my child, I've just made a gift. And technically, it's a taxable gift. I can give away, but here on the slide, it shows I can give away up to $15,000 a year, and I don't even have to file a gift tax return. The IRS doesn't even want to know that I did it. If I give away more than $15,000 a year, then I have to file a gift tax return. But in addition to that annual amount, there's also a lifetime exemption of over $11 million. And so until I've given away $11 million, there's no gift tax. Now, that number sets a sunset in a few years and come back down, but even then, it's still going to be in the multiples of millions of dollars. And so for most families, we don't have to worry about gift and estate tax at the federal level, because we're never going to have that much money. And so putting assets into the trust, not really a taxable event. Taking distributions from the trust and giving them to the kids, now that might be a taxable gift, but until you give away more than $11 million during your life, nobody's paying any taxes. So we're not really worried about the taxes. I can't say there are no tax consequences of the sort of scenarios that I laid out there, but for most families, we're not paying any additional taxes. But then Pennsylvania has a death tax called the inheritance tax. I'm not going to spend a ton of time here, but the idea is if you pass away as a Pennsylvania resident, someone's going to pay some tax, or at least the assets are subject to the tax. It's 0% between spouses. 4.5% death tax if you're leaving assets to kids, grandkids, or to your parents, lineal ascendants or descendants. So 4.5% in most situations. 12% if I'm leaving assets to my brother or sister, siblings, 12%. 15% anyone else. Nieces, nephews, friends, neighbors are going to get hit with a 15% death tax. Now, in most situations, if you have some stuff and you've got kids and you're giving the stuff to the kids, we're just going to pay the tax. It's 4.5%. I mean, there have been days when I'm recording this, there's been days real recently where we lost 4.5% in the stock market in a day, right? And so it's terrible. Nobody wants to lose money. But at the same time, you're not going to give up control over your assets to save your kids 4.5% death tax. If your kid is going to inherit $100,000, he can afford only taking 95.5. We're not going to rearrange your life over it. And I think that that's probably correct thinking, because planning for the inheritance tax is at odds with the next point here, and that's capital gains. And here's real quick down and dirty on capital gains. If I buy an asset, let's say I buy a house low. I bought a house for $50,000, and that house is now worth $150,000. So my tax basis is $50,000. When I sell it for $150,000, the difference, that $100,000 difference, is my gain. And a capital gain is going to be taxed at probably 15 to 18% combined federal and state. Now, here's the thing. If it's my primary residence, it's exempt from the capital gains tax. They exempt the sale of the primary residence up to certain levels. And for most of us, we're not going to exceed that. So, but like if it were stock, or if I'm selling a second piece of property that might have been a rental property, if I bought it low and I'm selling it high, there's going to be a difference. That difference is the gain, and I'm going to be taxed on it. Now, here's a few concepts to understand about capital gains taxes. One of the things that I see out there happening is families want to protect their house from the nursing home, or they want to protect their money from the nursing home, and they know they got to be broke. And so they want to give the assets to the kids. But when you give assets to the kids, if you put your house in your kid's name, then you've given them your basis. So in my prior example, if you own a house for $50,000 and it's now worth $150,000, if you give that house to your kid, the kid owns it for the $50,000. And if the kid later sells it for $150,000, they're going to have to recognize a $100,000 gain, taxed at 18%. So probably a pretty big tax mistake. And what happens, unfortunately, is people want to protect these houses, so they're putting in the kids' names. Then the kid, then 7 years later, dad needs to go to, say, like an assisted living facility. We need some cash. So the kid wants to sell the house to come up with the cash to pay for dad's care. And the kid is now selling it. It's not his primary residence. We're going to get dinged with capital gains taxes. One last thing on this. If dad instead had owned that property and his social security number until he passed away, if it was included in his estate when he passed away, the kid gets what's called stepped up tax basis, meaning the kid owns the property for date of death value. So rather than the 50 grand that dad owned it for, if the kid inherits it, the kid now owns it for $150,000. He can sell it for $150,000, and he doesn't have to recognize the capital gains. So all else being equal, from a capital gains tax standpoint, we want our children to inherit assets rather than receive them as a lifetime gift if they've had big gains. This is why I made a big point of saying that the asset protection trust earlier, remember, you put the house in it and you put a lid on it, but it still has your social security number. Because if it's still in your social security number, if it ever has to sell, we don't have to recognize capital gains tax on the sale of the primary house. When you pass away, we get what's called estate inclusion, which means the trust still gets stepped up tax basis. So we don't make that capital gains tax mistake. So just kind of a real quick recap on all of this. I know it's confusing. People want to protect their stuff from the nursing home, but if they give it to their kid, they've maybe made a capital gains tax mistake. If instead we put it in the trust, we still protect it from the nursing home, but we didn't make the capital gains tax mistake. We still have an exempt sale of a primary residence, and we still get the stepped up tax basis at death, and it really can work in a good situation. Another planning issue that comes up quite a bit in the office is family member stuff. I'm gonna, one of the most complicated things is like planning with second marriages, and we got kids on both sides, and how are we gonna manage this thing when the first spouse passes away? That can be pretty tricky. I wanna talk to you about one thing that's pretty popular in our planning, and this is, if you have assets and you're leaving your assets to the kids. I get a lot of questions in my office about, if I leave my assets to my kid and my kid gets divorced after I've given them their inheritance, what happens, right? If I leave my assets to my kid, pays off the mortgage on their jointly held house with his wife, and then my kid then pays off the spouse's student loans, and then they use it for home repairs and vacations and stuff, and then 5 or 6 years later, my son has a divorce. What happened with all that money? And we can't even tell, like sometimes people say 50-50. Well, we can't even tell what is 50-50 anymore. And so one thing that you can do is rather than leaving, like let's say you want to leave assets to your daughter, and you're not sure, maybe she's not married yet, so we're not sure about who that might be, or she is married and we're really not sure about this person. I could, instead of leaving my daughter her inheritance outright, I could leave my daughter her inheritance in her own, what we call a separate share trust. She gets her own separate share of the inheritance in a trust that she can be in control of, and she can manage, and she can get to, but it is asset protected from her potential creditors, like a divorce and a lawsuit. And so if we sit down and have a conversation about it, we're going to chat with you about, do we want to do protection from your kids' potential issues like divorces and lawsuits? And that usually is going to involve giving your kids their inheritance in a trust. Now I'm going to move on to planning for long-term care. Long-term care is expensive. Staying at home can vary because you could be healthy or you could be very unhealthy, and that could require a whole bunch of hourly work to take care of you. Independent living could be a patio home or like an apartment building with cafeterias in the basement and whatnot. This is really more about standard of living, ease of living, than it is a medical situation typically. At a personal care home, a pretty common fee for a month in a personal care home would be about $5,500. And then nursing homes, we're talking here about skilled nursing facilities. That's almost $11,000 a month in Pennsylvania. So anyway, you look at it, it's expensive. So how are we going to pay for it? The first is you're going to pay privately. If you don't do anything else, the government's rule book requires you to kind of go broke on care, which is really kind of a tragic thing, because you're going to go broke on a healthcare event that you have no control over. And as I'm going to show you in a minute, Some healthcare events when you're a senior, you're financially secure, some you're not. But if you need long-term care, like care in a nursing home, you will go broke before you get any other help. Long-term care insurance is an option. Most people don't buy long-term care insurance because of the expense. This really isn't a talk on that. There are some interesting options out there we can introduce you to folks. And then there's the government. And when we're talking about the government, 3 agencies to be thinking about: Medicare, the VA, and Medicaid. Now, Medicare is not in the long-term care business. This is the biggest area of confusion. Medicare pays for acute care. Medicare will pay for a heart attack and the open heart surgery and the treatment related to a heart attack. But Medicare does not pay for long-term custodial care that may be thought of like with Alzheimer's disease or stroke patients, right? So you've got this sort of situation where we're all paying into this Medicare system. And when we're seniors, we're supposed to have health care, but whether Medicare pays for your health care when you're a senior is heavily dependent on what healthcare event you have. People with heart attacks have their care paid for. People with Alzheimer's disease, largely the care associated there, the custodial care is not paid for. And so, it's great that we have Medicare, but you cannot rely on Medicare to pay for your long-term care expenses. I'm going to breeze through the VA today because the VA is could be its own hour presentation. Just understand that if you are a veteran, or if you are the widow of a veteran, or if your parent is a veteran, you got to look at the VA health system, and I'm happy to talk to you about that today, but I'm gonna sort of skip it for brevity's sake. Then there's Medicaid. Now, Medicaid is the name of the game when it comes to the nursing home. Medicaid pays for almost all, it's like 2/3 nationally of long-term care stays in a nursing home are paid for by Medicaid. And so people tell themselves stories about Medicaid. Like, if I end up on Medicaid, I'm going to be in the county home in the broom closet with like 3 or 4 other people. And that's not how it works. Medicaid, most of the nursing homes, at least around here, will take Medicaid. Now, they're not full with Medicaid, but a lot of them have a lot of Medicaid. And so you could walk into most skilled nursing facilities around, and there's a person on this side of the hall and there's a person on this side of the hall, and this person's paying $11,000 a month. This person's on Medicaid and not paying $11,000 a month, and it's the same nurse walking back and forth across the hall. Now, these rules are crazy. Here's sort of an overview. You have to keep in mind that that they treat single people differently than they treat married people. Now, I'm going to do a different video entirely on Medicaid application, but a single person is essentially going to go broke. You can only be up to $8,000 of available resources, which is pretty much everything you own has to go and be below $8,000, except for your house and your car. You're allowed to have a house and you're allowed to have a car. Pretty much everything else has to go. And then once you're eligible from an asset standpoint, all of your monthly income, like your pension or your Social Security check, ends up going to the nursing home. And so you're out of money, you're out of income, and it makes life real hard to be able to keep that house because you don't have any cash. You don't have cash for property taxes or utilities and whatnot. And so then what happens is families will sell that house. Now they have a bunch of cash, not allowed to have a bunch of cash. We end up losing Medicaid eligibility, and the whole thing is pretty ugly. But the long story short, a single person will go to $0 between eligibility and when they pass away. If you've been on Medicaid, when you pass away, the state has a claim against your estate for whatever's left, which can only really be the house and a car. And so a single person on Medicaid long enough, in the nursing home long enough, is going to go broke. Now, it works pretty similar on the married couple side of things, except that the healthy spouse, there's a couple of nuances. The healthy spouse, at least right now in Pennsylvania, other states don't do this, but at least right now in Pennsylvania, the healthy spouse is allowed to keep their own retirement accounts, and they're allowed to keep half of the other assets up to a maximum of $128,640. So if husband goes in the nursing home and wife is healthy in the community and they have $100,000, the wife, the healthy spouse, is going to be allowed to keep $50,000. The other $50,000 is available for dad's care, and he's probably only allowed to keep $8,000. So that family is going to go through $42,000 before they're eligible for Medicaid. Now, the half mom's allowed to keep in that scenario is capped at $128,000, $128,640. And so if the family had $400,000, mom doesn't get to keep half anymore. She's capped out at $128,000. Now, the healthy spouse's income is always safe. And depending on how the state has a formula, depending on how the math works out, she may be allowed to keep some of dad's income too. But this situation is really difficult on her because pretty soon, she ends up going through her income. She ends up going through the money that she was allowed to keep anyway, and she gets into pretty dire circumstances. Now, people don't know this level of detail, but people know generally, hey, I got to be broke if I go to the nursing home. So what do? They end up giving the assets to the kids. And if you give your assets to your kids, then one, you made a control mistake. You end up giving your assets to your kids. But the second problem is you probably made a capital gains tax mistake. The third problem is Medicaid doesn't want you to give away your stuff. They've got this 5-year look-back period. So if you give away your stuff and then need to apply for Medicaid, they ask, have you given anything away in the last 5 years? And if the answer to that is yes, then there's going to be a period of ineligibility for the Medicaid program, which can result in the nursing home not being billed and then not being paid, and then some ugly scenarios. So look, a lot of families ask me, should I put my house in my kid's name? Should I give my money to my kids? I think it's pretty risky because you give up control. The second is you probably made a capital gains tax mistake if you gave away a house that had grown in value. And the third is this 5-year look back period. So is there a better option? Yeah, I think that the asset protection trust is a better option. And here's really the key. When I do this talk with a bunch of people in the room, and I ask this question, I say, if you gave your stuff to your kid and then you got sick in the next 5 years, could your kid give that money back? Like if you gave your money to your kid 4 years ago, if you gave $100,000 to your kid 4 years ago, could you get it back this afternoon? And they usually have this kind of nervous laugh because no, you can't. 5 years is a long time. The state knows it's a long time. That's why there's a 5-year look back period. What I feel comfortable about is if you want to do asset protection trust, or if you want to do asset protection generally, rather than putting the stuff in the kid's name, you put the stuff in an asset protection trust because the money sits there for the next 5 years. For the next 5 years, it's not subject to your kids' spending habits. It's not subject to your kids' gambling problems. It's not subject to your kids' divorce. It's not subject to any of that stuff. The money's still sitting in the trust. And if we don't make it through the next 5 years, I know where your money is. You can make a distribution to your kid at that point, and assuming they still love you, they're going to give the money back, and you've got sort of this back door. So I think it's a way more convenient way, a way more conservative and safe way to plan for this stuff. Just quick note, if you have been told you're not eligible for Medicaid, check out our website, check out our information. I'm going to do another video on Medicaid spend down planning, but just understand that even if you have a loved one in a nursing home already, there are still some steps that you can take to protect assets. We're not going over them in today's talk. It's its own long talk, but understand that if you work with an elder law attorney, especially a certified elder law attorney that has a bunch of experience in doing this stuff, there are still frequently some steps you can take to protect assets. I want to chat with you a little bit here about my process. It's typically a couple of meetings. Now, as I'm recording this, it is mid-March of 2020, and we're actually kind of right in the heart of this sort of coronavirus. Not sure if we're going to be allowed to have a whole bunch of client appointments. So any of these, except for the signing meeting, could be done on a Zoom meeting over the internet. But the idea here is one meeting is the vision meeting, the first meeting. So you come to this meeting and it's education based. So we review your situation. We talk to you about your options. We understand what your goals are. What are your concerns? My goal at the end of the meeting, or my team's, depending on who you meet with, is here's your stuff. Here's your goals. Okay, understanding now your family dynamics, understanding your money. Here's a couple of options for you. And then here's what it costs. So we tell you what the assets are, or what the prices are. I work 100% on flat fees on estate plan. So we've got wills that cost this. We've got trusts that cost this. What we try to do in this meeting is focus the conversation on what is it that you want to accomplish. Then we tell you, okay, given what we've known, you can use this as your tool. You could use this as your tool. Here are the prices. Go home and think about it. So we typically aren't going to pressure you to make a decision in the first meeting. From my standpoint, I think this is a lot of information and you need to sort of take it slow. Second meeting is what we call the design meeting. Now at this meeting, most families are able to make a decision because you've heard the information I presented today. You've had a free consultation. We've got you some stuff. At this meeting, typically, our families make a decision. Then we get the information we need to write your documents. Then we move on to the next meeting, which is where you sign your documents. And then we go through this process called trust funding if we're going to do a trust. Sometimes it's just beneficiary designation work if you're not. But it does you no good to spend money on an estate plan and then not move the assets into it or not coordinate with the beneficiary designations. And so it really takes a comprehensive plan. So we would work with your financial folks, and I'd give you instruction to say, hey, you need your beneficiary designation to say this, or we need to retitle the account to say that. And then we work with your financial folks to make that happen. And then I like to see my clients once a year because this is confusing stuff. And so we have a maintenance program. Your life changes, my life changes, the law changes. And so it's helpful to sit down from time to time to say, okay, given what's changing, do we need to change the estate plan? So that's what the maintenance program is all about. And that's it for today's talk. I know we covered a lot of ground. The purpose of the talk was not to have you become an expert on estate plan. The purpose of the talk was for you to hopefully understand a couple of different types of documents we use, and then get a step or two ahead so that when you do sit down with us, when you do sit down with a lawyer, you've got some background information. Then you can, we can go to those sort of 200 level questions. We can get to the more nuanced stuff and really get you moving along the way. So I appreciate your watching the video. I hope that you learned a lot. I know I speak fast, and I hope that didn't drive you nuts, but I'm trying to present a bunch of information to you, and I hope you found it helpful. So check us out. My law firm is called the Sechler Law Firm. We're helping families across Pennsylvania. My phone number is 724-841-1393. You can check us out at sechlerlawfirm.com. Drop me an email at info@sechlerlawfirm.com. There's lots of ways to get in touch with us, but if you want to move forward with this process, we deal with a lot of different types of families and a lot of different types of situations. We have flat fee pricing. You understand the pricing up front, and then you can make a decision based on your best interests. So it's been a pleasure. Again, Tim Sechler, Sechler Law Firm. I look forward to meeting. Thanks.